September 16, 2024. Federal agents arrive at two properties simultaneously. One in Los Angeles, one in Miami. They are searching the home of a powerful man. Months earlier, a video had surfaced. A hotel corridor. A woman. And a man the world recognized. That man was Sean Combs. Within days of his arrest, over 120 civil lawsuits were filed. By the time the jury returned its verdict last July, the world had seen a private world of violence, coercion, and manipulation that prosecutors said operated like a criminal enterprise. Built around one man's absolute need for control, he was convicted. He was sentenced to more than 4 years in federal prison. And everyone assumed that was the end. It wasn't. This week, Sean Combs was back in federal court. Not for a new crime, but fighting to walk free on a legal argument that could rewrite how justice works in America. Part 1. How we got here. To understand what happened in that Manhattan courtroom this week, you need to understand what happened at the trial, and, crucially, what the jury actually decided. Sean Combs faced 5 federal charges. The most serious were racketeering, conspiracy, and 2 counts of sex trafficking. These were the charges that could have sent him to prison for the rest of his life. The jury deliberated for days. They told the judge they were deadlocked on the racketeering charge. Feared, unpersuadable members on both sides. The judge sent them back. Hours later, they returned with a verdict that shocked many legal observers. Not guilty on racketeering conspiracy. Not guilty on sex trafficking. But guilty on 2 counts of transportation to engage in prostitution charges under the federal Mann Act, a law dating back to 1910, which bars transporting people across state lines for any sexual crime. 2. The verdict was a split decision. The jury believed something happened, but could not unanimously agree on the most serious characterization of what it was. Then came sentencing. And this is where the story gets legally explosive. Judge Arun Subramanian sentenced Combs to 50 months in prison, more than 4 years. His lawyers were stunned. Defendants, convicted of similar offenses, typically receive around 15 months. Combs received more than 3 times that. Why? Because the judge was required to consider all of his history, his background, his character, his conduct, including, crucially, the conduct a jury had acquitted him of. The abuse, the coercion, the violence, the freak-offs that the prosecution had detailed in graphic testimony from his former partners. The defense called it a perversion of justice. The prosecution called it the law. And now, 18 months after his arrest, that question is before the Second Circuit Court of Appeals, part of the appeals hearing. On the morning of April 9, 2026, 3 federal appellate judges took their seats in the Second U.S. Circuit Court of Appeals in Manhattan. Sean Combs was not in the courtroom. He was at Fort Dix Federal Prison in New Jersey, where he has been held since his arrest. His defense attorney, Alexandra Shapiro, had 2 central arguments. Each one cuts to the heart of how the American justice system is supposed to work. The first argument: the judge punished Combs for crimes the jury said he did not commit. Shapiro told the panel directly their unanimous verdict was not guilty on the most serious charges. The jury did not authorize punishment for sex trafficking or conspiracy, but that is what drove this sentence. Her core principle was simple: not guilty should mean not guilty. If a jury acquits a defendant, a judge should not be able to effectively sentence them as though they were convicted. D. The second argument: the First Amendment. Combs' legal team argued that the filmed sexual encounters at the center of the Mann Act conviction, what prosecutors called freak-offs, constituted a form of expression protected by the Constitution. Amateur pornography, they called it. And if the First Amendment protects expression, the question becomes, at what point does consensual, documented adult sexual activity cross into federal crime. Prosecutors had a sharp response. Assistant U.S. Attorney Christy Slovic argued that if Combs was right, then any criminal enterprise that filmed its activities could claim constitutional protection. Any defendant who transported others to engage in prostitution could escape liability simply by watching or filming the sex, she told the court. And on the acquitted conduct argument, she pointed to a specific moment that she said encapsulated the entire case: a flight home from the Cannes Film Festival, during which Combs allegedly showed Cassie Ventura videos of their previous sexual encounters and threatened to release them. Hours later, another free cuff, Ventura testified. "I just felt trapped. Like, how do you get out of this situation?" It's what he's asking for. The threats are not followed by a request to go to dinner, a request to ask Cassie to do the dishes. Those threats are followed by a demand. Prosecutor Christy Slavic, Second Circuit Court of Appeals, April 9, 2026. After 2 hours of argument, the 3-judge panel retired without issuing a ruling. Circuit Judge William Nardini described it as an exceptionally difficult case that raised questions not only for this court but for any federal court in the country. That phrase, first impression, is a term of art in the law. It means this precise question has never been answered at this level before. Whatever these judges decide will set precedent. We're going to get into the broader legal implications of this case in a moment, because what these 3 judges decide will affect not just Sean Combs but every future federal sentencing in America. Stay with me. But first, if you found this breakdown valuable, subscribe now. We cover cases like this with the depth that the news cycle doesn't have time for. And I want to know your take. Do you believe a judge should be able to consider acquitted conduct at sentencing? Leave your answer in the comments. I read every one. Part 3. The bigger legal question. Here is why this case matters far beyond Sean Combs. Why legal scholars across the country are watching this ruling very carefully. The practice of judges considering acquitted conduct at sentencing is not new. It has existed for decades. The logic behind it is this: a criminal conviction requires proof beyond reasonable doubt. But sentencing, determining the length and conditions of punishment, has historically operated under a lower standard. A judge at sentencing can consider relevant conduct, even if a jury found there was insufficient evidence for a conviction. Courts have repeatedly upheld this practice. But in recent years, the legal ground has shifted. The U.S. Sentencing Commission issued new guidelines explicitly prohibiting acquitted conduct from being used to increase a sentence. Combs' defense team argued that those new guidelines, combined with the extraordinary gap in his sentence, and what a typical defendant in his position would receive, make his case different. At the heart of it is a question every citizen should care about. What does not guilty actually mean? Fig. If a jury of 12 citizens hears weeks of evidence and returns a verdict of not guilty, does that mean the defendant walks free of those allegations entirely? Or does it simply mean the evidence did not clear the criminal bar, and a judge remains free to treat those allegations as real when deciding how long someone spends in prison? The defense position is philosophically straightforward. Not guilty must mean something. The prosecution position is legally precedented. Acquittal is not the same as innocence. It means only that reasonable doubt existed. And reasonable doubt is not the standard for sentencing. Judge Nardini himself acknowledged the tension. He noted that the Second Circuit has previously held it was constitutional for judges to consider acquitted conduct, but he also acknowledged the guidelines had changed, which means whoever loses this hearing is almost certainly taking it further, possibly all the way to the Supreme Court. And if the Supreme Court were ever to rule that acquitted conduct cannot be used to enhance a sentence, the implications for thousands of current and future federal cases would be seismic. Part 4. What the trial revealed. Step back from the legal architecture for a moment, because the trial itself deserves examination in the context of what comes next. The prosecution spent 8 weeks building a picture of a man whose power, fame, and wealth had insulated him from accountability for years. Witnesses testified to a world of violence and coercion, or operating behind the glossy surface of one of music's most celebrated empires. Cassie Ventura's testimony describing being trapped, threatened, and degraded was described by observers as among the most harrowing testimony they had ever witnessed in a federal proceeding. And yet, the jury acquitted on the most serious charges, not because they disbelieved everything, but because the legal standards for racketeering and sex trafficking are specific, demanding, and unforgiving. The jury found that the evidence cleared the bar for Mann Act violations, interstate transport for prostitution, but did not, unanimously, clear the bar for a criminal enterprise or forced sex trafficking. That gap between what the jury found and what the judge believed, the evidence showed, is precisely what Combs' lawyers are attacking. It is worth noting what the judge said at sentencing. He told Combs directly, "You abused the power and control with women you profess to love." He is not a man who believed Combs was innocent of the broader conduct. 2. Is a judge who believed the law required him to consider that conduct and who exercised that discretion at the maximum end of what the guidelines permitted. The defense called this acting like a 13th juror. The judge called it following the law. Outro and forward look. The 3-judge panel has not yet ruled. There is no timeline for when they will. It could be weeks, it could be months. And whatever they decide, whether they uphold the sentence, reduce it, or send the case back, it will land in the middle of an already explosive national conversation about power, accountability, and who the justice system protects. Sean Combs is currently scheduled for release in April 2028. If his lawyers succeed on the acquitted conduct argument, that timeline could change dramatically. If the court rules against him and the panel's pointed questions suggest nothing is certain, he will serve his term, and the legal question moves one step closer to the Supreme Court. What this case has already done, regardless of the outcome, is crack open a question. Thoughts? That the justice system has long preferred to leave in the dark. When a jury says not guilty, what does that actually guarantee? Does the verdict speak? Or does it whisper just loudly enough to stay the most serious punishment, but not loudly enough to protect someone from everything else that follows? That is not a question about Sean Combs. That is a question about all of us. I will be covering this ruling the moment it drops. Subscribe and hit the bell so you don't miss it. And if you want to go deeper on the original trial, the evidence, the witnesses, the verdict, I have a full breakdown linked at the end of this video. Thank you for watching.